There are numerous documents that are involved in an S corporation, and when you're setting up an S corporation, it's important to be aware of what these documents are. A lot of them are boilerplate, which means they may not be changed from one company to the next, but it's important to know the scope of what these documents are. First, you have articles or certificate of incorporation, and we talked about that in a previous segment. The next is the actions of incorporator. Again, we talked about the incorporator and the incorporator's role in filing the certificate or articles of incorporation and selecting the directors and also approving the bylaws. The actions of the incorporator document those particular actions that the incorporator has taken, and also indicates that once the incorporator has engaged in those activities, their role is finished in the company. In order to form an S corporation, the company has to file an IRS Form 2553. That's an election that you can get from the irs.gov website that indicates that the company will be taxed as an S corporation. In order for the election to be effective for that tax year, it's got to be filed before the 16th day of the third month of that tax year. Otherwise, the election will be effective the following tax year. Be sure to talk to an accountant or your attorney before filing that S election to make sure when it is effective. You will also need to make sure that the shareholders adopt a resolution that approves the S election and that the shareholders agree they will not be engaged in any activities that impair the S election status. For example, by authorizing more than one class of stock. The S election will stay in effect until it is terminated or until it is revoked. Oftentimes, startup companies will form an S corporation when they know that they are not going to get outside funding for a while and they're going to be receiving a lot of profits and want to make sure that they get the more favorable tax benefits of that S election. For example, if the shareholders are paying themselves and they want to make sure that they avoid a certain amount of self-employment tax, they can elect to be taxed as an S corporation. But then if the company later decides that they're going to accept venture capital financing, they can revoke the S election so that they'll be able to be taxed as a C corporation and they can accept that venture financing. The company's bylaws determine the management of the company and sets forth the responsibilities of the shareholders, the directors, the officers in the company. Generally, the shareholders will be making major decisions on behalf of the company. So, for example, if the articles of incorporation need to be amended, the shareholders are often responsible for making that decision. There are numerous responsibilities that are determined by the bylaws, including the meetings of the shareholders, the meetings of the directors, how directors are elected or removed. So although these are typically standard provisions in bylaws, be sure to read them, understand them, and make sure they apply to your company's situation. In addition, the bylaws contain indemnification provisions or limitation of liability provisions. The indemnification provisions basically provide that the company agrees that they will pay for any expenses that directors or officers have had to pay while acting on behalf of the company. Again, this is because the directors and officers have heightened duties to act in the best interest of the company. So these indemnification provisions allow for the directors and officers to be protected if appropriate. The limitation of liability provisions allow for the same thing. And so the limitation of liability provisions basically require the company to be responsible for certain actions of the directors or officers as opposed to the directors and officers themselves. The board consent is the initial document that ratifies the actions of the incorporator and also makes many administrative decisions of the company while setting the company up. For example, the consent will determine who the officers of the company are, how much stock will be issued to the shareholders in the company, and if there's going to be a stock option plan adopted. The board consent also deals with other administrative matters, such as opening bank accounts and determining who will sign on behalf of the company. The company needs to make sure that not only with this initial board consent, but other board decisions are documented in similar resolutions or will be documented in meeting minutes of the company. The shareholder consent essentially has the shareholders approve any indemnification agreements between the company and the directors. And for an S corporation, it has to approve of the S election by the company. If the company will be adopting a stock option plan, the shareholders must also approve that plan. As I explained earlier for the bylaws, the directors and officers will be indemnified for certain expenses that they pay on behalf of the company. The company will often have the directors and officers enter into longer indemnification agreements that provide more detail about the process of indemnification and how it will work for the particular directors or officers. The restricted stock purchase agreement is the document where the shareholders of the company will purchase their stock in the company. And if the company decides that they want to impose a vesting schedule on the shareholder, then this is the document where that would be done. What this means is that the shareholder would receive all of their stock in the company up front, but the company would have a right to repurchase the stock if certain triggering events occur. Typically, a company would impose vesting restrictions on a shareholder's stock in order to incentivize that shareholder to work with the company. The typical vesting provisions are a 4-year vesting schedule with a 1-year cliff. This means that the shareholder would not receive any vested stock up front for a year. After a year, a quarter of their stock would vest, and then every month for the next 3 years, their stock would vest. The restricted stock agreement is a very important tool for the company to make sure that shareholders stay actively involved in the company, and if not, this gives the company the right to buy back the shares and to get rid of the dead weight of shareholders who aren't interested in working for the company. The IP assignment is another important document when setting up an S corporation because that is the document that would assign the intellectual property of the shareholders to the company. And this would be the intellectual property that the shareholder created before the company was formed. The Confidential Information and Invention Assignment Agreement is an agreement that the shareholder would sign that essentially assigns the intellectual property of that shareholder to the company while the shareholder is working with the company after it is formed. So both of the documents are necessary to make sure all of the intellectual property of the shareholder belongs to the company. These two agreements should be signed by all employees, shareholders, and independent contractors involved with the company. Stock certificates are documents that are used to show the number of shares that a stockholder has in the company. The stock certificate isn't necessary, but it's important to have at least some documentation of the shares that a company has issued to shareholders. So if you don't want to issue separate stock certificates, you could issue notices of issuance of stock, which set forth the number of shares that a shareholder has in the company.